In February 2024, Uttarakhand became the first Indian state in decades to pass something called a Uniform Civil Code. One set of laws for marriage, divorce, inheritance, no matter what your religion is. Now, if you are wondering why that is a big deal, here is the thing. Right now in India, the law that applies to your marriage actually depends on what religion you belong to. Hindus follow one set of rules, Muslims follow another, Christians have their own, and this has been the case since British times. It's kind of strange because India's constitution says the government should create a uniform civil code, meaning one law for everyone. It is written right there in Article 44. But here we are, after 75 years of independence, and it is still never happened nationwide. And it is not actually like people haven't tried. Jawaharlal Nehru, India's first Prime Minister, actually wanted this, but he ran into serious pushback, particularly from Muslim leaders who worried it would erase their community's identity. So rather than force it, Nehru and other leaders made it the goal government should work towards, but not something it had to do. But the roots go back even further. In 1860s, when the British were creating laws in India, criminal law, contracts, evidence, they made a very careful choice. Don't touch personal laws. Why? Because they were scared of religious conflict. The 1857 rebellion was still fresh in memory. So they left marriage, divorce, inheritance, all of that to be decided by each community's own rules. And that system, it basically carried over into independent India. Fast forward to today, and the debate is more intense than ever. Supporters say the UCC is about equality, especially for women who often get a raw deal under religious personal laws. Critics says it is really about one community forcing its value on others. So what is really going on here? Why has this been stuck for so long, and why is it suddenly making headlines again? To understand that, we need to go back to how India ended up with this marriage system in the first place. Right, so to really get why India has different laws for different religions, we need to go way back, like ancient India back. In ancient Hindu tradition, law and religion were not separate things. Religious texts like the Manusmriti laid down rules for everything: how to pray, how to get married, how to divide property, social life, legal rules, religious duty. It was all bundled together. And importantly, these were seen as religious obligations, not something a king could change just on a whim. Fast forward to medieval India under Muslim rulers. They brought Islamic law based on the Quran and teaching of Prophet Muhammad. But here is the interesting part. Even then, when it came to personal stuff like marriage, inheritance, communities were mostly left alone. So Hindus followed Hindu law, Muslims followed Islamic law. The rulers did not really interfere. So this idea of separate personal law, it is not new. It has been around for centuries. And when the British showed up, they looked at this system and thought, you know what, we are not touching that. In 1772, the Governor General Warren Hastings made it official. Muslim would follow Quranic law, Hindu would follow their religious text. Each community got to keep its own rules for family matters. Now the British were happy to standardize other areas of law. In the 1860s and 70s, they created the Indian Penal Code, the Evidence Act, laws of contracts, all uniform, but personal laws, they deliberately left those alone. Why? Because they were terrified of sparking religious violence. The 1857 rebellion was still a fresh wound, so they figured better to let communities govern themselves on marriage and family stuff than risk another uprising. By the early 20th century, though, reformers in India started pushing back, especially on issues affecting women. In 1929, the British passed a law setting minimum marriage age 18 for boys, 15 for girls. It was supposed to apply to everyone. But Muslim leaders strongly opposed it, seeing it as interference in religious matters. And in 1937, to calm things down, the colonial government passed another law that basically said, okay, Muslim personal law is protected, we won't interfere. So, on the eve of independence, India had this a patchwork of personal laws, each tied to religion with no unified code inside. After independence, there was a big push to modernize these laws, especially Hindu personal law, which many saw as unfair to women. In the 1940s, a committee drafted what was called the Hindu Code Bill. It would have completely overhauled Hindu marriage, divorce, inheritance, and adoption laws in one go. Ambedkar championed it. He saw it as essential for building a modern, equal society. But it ran into massive opposition not just from conservative Hindus but also from Muslim leaders
Who worried if you can change Hindu laws, will you come for ours next? The bill was so controversial that it was eventually shelved. But then in the mid 1950s, the government got creative. Instead of passing one big bill, they broke it into smaller pieces and passed them one by one. The Hindu Marriage Act in 1955, the Hindu Succession Act in 1956, a couple more that same year. By breaking it up, they managed to get through the reforms, but only for Hindus. Now you might be asking why only Hindu law? Why not reform everyone's laws at the same time? Ambedkar actually explained this. He said, basically, if we can successfully reform Hindu law, and if those reforms work well, other communities might see the benefits and ask for their own laws to be updated. Lead by example, don't force it. So meanwhile, other communities continued under their own laws. Muslims followed Islamic law, Sikhs had their own marriage law from 1909, Parsis had theirs from 1936, Christians followed the one from the 1872. Over the years, these laws got tweaked here and there, sometimes by parliament, sometimes by court rulings, but the basic setup stayed the same. Your religion determined which family laws to be applied. But what about the Uniform Civil Code itself? Where does that fit? Well, when India's constitution was being written in 1948, the leaders debated whether to make UCC a fundamental right, something the government had to do, or a directive principle, something it should work toward. The debate in November 1948 was pretty intense. Muslim leaders argued a UCC violates religious freedom. You cannot force one law on everyone when our identities are tied to our religious traditions. Supporters like Ambedkar and others argued that a UCC is about equality, especially for women. It is about building a modern nation where citizens are equal before the law, regardless of religion. In the end, they compromised. Article 44 went into directive principle, which translates to the government should work towards a UCC, but it is not legally required. It was left for future governments to figure out whenever they could get everyone on board. And for decades, that is where it stayed stuck. Why? Because personal law became deeply political. The Johnson and later the BJP made a UCC a core part of their agenda, alongside issues like Ram Janmabhoomi. They framed it as necessary for national unity and gender equality. But opposition parties, especially those counting on Muslim votes, saw it differently. To them, it looked like Hindu nationalist politics dressed up as legal reform. So every time UCC came up, it became this huge fight, and no government wanted to touch it because the political cost seemed too high. Even when BJP won big in 2019, giving them real power in parliament, they still did not push for national UCC. Why not? Partially because even some of their coalition partners were nervous about it, and partially because in 2018, 21st Law Commission had basically said, maybe we don't need a full UCC right now, maybe just fix the worst parts of personal laws within each community. Instead, the BJP took smaller steps. They banned triple talaq, which let Muslim men instantly divorce their wives. They removed special status from Jammu and Kashmir. These were seen as moves towards UCC, testing the waters, but not the full thing. After the 2024 election, where the BJP lost its majority, a national UCC seemed even less likely, at least for now. But here is where things get interesting. While the national debate was going on in circles, state governments started experimenting. And in February 2024, Uttarakhand did something no major state has done in decades. It passed its own uniform civil code. What is actually in this law? Who is celebrating? Who is furious? Let's look at that next. February 6, 2024, the Uttarakhand Assembly passes a uniform civil code, making it the first state in independent India to actually do this. Goa technically has one, but that is leftover from Portuguese rule. This is different. This is modern Indian state saying we are doing it. The law covers marriage, divorce, inheritance, maintenance, and this is where it gets interesting. Live-in relationships. It applies across all religions, Hindu, Muslim, Christian, Sikh. Everyone follows the same rules now. Well, almost everyone. Because right away, scheduled tribes are exempted. They protested, said their traditional laws are protected under the constitution. And the government backed down. So the uniform code not actually uniform from day one. Minister Pushkar Singh Naik defended this. He said this isn't about appeasing anyone. It is about keeping a promise. And they did promise this. The UCC was in the BJP's 2022 election manifesto for the state. So what is this law? Let's start simple. Marriage age is now the same for everyone. 21 for men, 18 for women. Pretty straightforward. Polygamy is banned across the board. This mainly affects Muslims. Since the Islamic law allows men to have up to four wives, now you can only have one legal spouse, no matter your religion. Practices like nikah halala are also one. That is where a divorced woman had to marry someone else and get divorced again before she could remarry her first husband. Now, if you want to remarry your ex, you just can. No middle step. And anyone who tries to force someone into the old practice, that is a crime now. But here is where things get really controversial. Living relationship. Under this new law, if you are living together, you have to register it with the government within a month. Don't register, you could face a fine or up to 3 months jail. Now think about for a second. The Supreme Court has already said living relationships are a personal choice protected under privacy rights. So how can a state government now say you have to register it? That is exactly what critics are asking. Congress MLA Bhuvan Chandra Kapri really went after this. He said, imagine the problems for women. These records creating family drama, complaints from angry relatives or nosy neighbors. Groups like Bajrang Dal poking into your private life. Daughters facing marriage problems because of these records. Blackmail becoming a weapon. And he is not wrong to worry. In a country where honor killings still happen, where interfaith relationships can trigger violence, forcing people to register living relationship could genuinely put them at risk. And here is another weird part. This law applies to all Uttarakhand residents, even if they live in another state. So if you are from Uttarakhand but working in Delhi or Mumbai and you are in a living relationship there, you are supposed to register it back in Uttarakhand. How does that even work? Nobody really knows. Now the government keeps saying this law protects women's rights, and look, in some ways it does. The ban on polygamy, getting rid of nikah halala, these give women more control. But dig a little deeper. You see the same old problems like guardianship. Under this UCC, the father is still listed as the primary guardian before the mother. So we are creating a modern uniform civil code that still says fathers have more authority than mothers. That does not sound very progressive. Then there is inheritance, which is where this law makes some real changes and where things get complicated. For Hindus, the UCC gets rid of the old distinction between the self-acquired property and ancestral property. Now all heirs have equal rights to both. Also, both parents, mother and father, are now top heirs, which is actually better for mother. For Muslims, this is much bigger shift. Islamic law traditionally gives son twice what daughters get. Fixed shares based on gender. Under the UCC, that is gone. Muslim women now have the same property rights as Muslim men. Equal shares. If you care about gender equality, that sounds great. But if you are Muslim who believes this is messing with religious law, you see it as the state imposing outside values on your community. Christians also see changes. Old law gave a widow one-third of her husband's property, with two-thirds going to children. Under the UCC, if there are no kids, the widow gets half. If there are no relatives at all, she gets everything. So that is clearly better for widows. But again, it is a state rewriting what were previously community rules. Now here is where it gets messy. The UCC does not really clarify what happens to Hindu undivided families. HUFs. These are legal structures used by Hindu, Sikh, Buddhist, and Jain families often to save on taxes. You pool family income, it gets taxed separately, usually at a lower rate. It is a pretty big loophole. A government commission has recommended getting rid of the system where sons automatically have rights to ancestral property. So inheritance could be truly equal for everyone, including daughters. But Uttarakhand's UCC does not fully address this. So HUFs exist in this weird grey zone. Then there is who is completely left out, LGBTQ plus people. The Supreme Court has recognized same-sex relationship. There are queer couples building life together, but this UCC does not mention them at all. So if you are in a same-sex partnership in Uttarakhand, what laws apply to you? The code does not say. You are just invisible in this supposedly complete legal framework. Unsurprisingly, all this has triggered major backlash. Muslim organizations say it violates religious freedom. Privacy advocates say the live-in registration is unconstitutional. Women's groups are split, some celebrate the polygamy ban and equal inheritance, others point out the law does not fix deeper patriarchal problems and legal challenges already filed. Multiple petitions are in High Court arguing the law violates constitutional protection for religious freedom. Meanwhile, other states are watching. Madhya Pradesh, Assam, Gujarat, all ruled by BJP. have hinted they might do their own version. So Uttarakhand isn't just experimenting for itself, it is potentially creating a template that could spread across India. Or it could become a warning about what happens when you rush major legal reform without proper discussion. So here we are. Uttarakhand has done something historic. It has taken an idea stuck in the constitution for 75 years and actually implemented it. Whether that is brave or reckless kind of depends on where you are standing. If you think personal laws have been holding India back from real equality, this looks like progress. If you think diverse communities should control their own tradition, this looks like overreach. What does this actually mean for India? Not just Uttarakhand but the whole country. Is this the start of a nationwide shift? Or will it spark so much resistance that the idea dies here? Can you even legislate equality, or does real change have to come from within communities? And is there any middle ground between complete uniformity and the fragmented system we have had for decades? That is what we need to figure out next. Actually do this. This goes all the way back to the founders. B.R. Ambedkar said a uniform civil code was a good goal, but he also said it should happen voluntarily, gradually, not be forced. That is why it ended up in Article 44 as something the government should work toward, not something it must do immediately. The big worry is Article 25, freedom of religion. If the government can override personal laws that come from religious texts, isn't that violating religious freedom? That is what critics argue. But the Supreme Court has actually addressed this several times. In multiple cases, the court has said yes, we protect religious freedom, but that freedom does not cover practices that go against public order or basic constitutional values. You cannot claim religion to justify something that violates equality or human dignity. And the court has not just defended UCC as constitutional, it actually pushed for it. In the Savanu case in 1985, the court said a uniform code would help national unity. In other cases, it urged Parliament to create one. And recently, in the Triple Talaq case, the court again signaled that fixing personal laws to match constitutional values isn't just okay, it is necessary. So the real question isn't can we do this, it is how do we do this without trampling religious freedom. And most legal experts say write it carefully, don't ban everything religious communities do. Just fix the parts that genuinely go against constitutional guarantees of equality and dignity. Things like polygamy, unequal inheritance, one-sided divorce laws, those can change without erasing religious identity. Now, in October 2018, the Law Commission actually said India does not need a uniform civil code right now. Instead, they suggested fixing the discriminatory part of each community's laws separately. But then a new commission started fresh consultation and they found something interesting. Support for UCC has grown, especially among young people in cities and among women. But the religious leaders and regional political groups still strongly opposed. They worry about losing cultural identity, about one dominant culture taking over. And here is the thing, India is not one unified bloc. It is the country with massive diversity, religions, culture, linguistic. Personal laws fall under something called the concurrent list, meaning both the central government and states have a say. So getting a nationwide UCC that is legally complex and politically explosive, you would need buy-in from different religions, different states, different political parties. That is why even when the BJP had strong numbers in 2019, they did not try to push through a national UCC. The politics just didn't work. But here is the workaround. State level courts. Uttarakhand did it. Other BJP ruled states are considering it. So instead of one big national law that triggers a massive fight, you might get multiple states gradually doing their own versions. Eventually, you might hit a point where a national code becomes possible, or you might end up with a patchwork where some states have uniform codes and others don't. Now, who actually wins if UCC happens? The clearest answer women. Feminist scholars like Flavia Evans, Ratna Kapoor, and Nivedita Menon have argued for years that when India allows different personal laws, what it actually does, it protects male control under the excuse of religious freedom. Unequal inheritance, one-sided divorce rules, lack of financial support after divorce, these aren't just traditions, they are tools that keep women in unequal positions. And fixing that, they argue, needs government action. You can't wait for communities to reform themselves because the people with power in those communities, usually men, have no reason to change things. So a well-designed UCC could genuinely transform women's life across all religions. Muslim women getting equal inheritance, Hindu women being recognized as equal guardians for their kids, Christian widows getting fairer property rights. These aren't just legal changes on paper, they are real improvement in everyday life. But, and this is important, only if UCC is actually written with women's rights as the main goal, not just as a political tool to show dominance. And there is the scheduled tribe issue, which might be the biggest practical roadblock to nationwide implementation. In 2016, a tribal organization went to the Supreme Court to protect their practices, including things like polygamy and polyandry, arguing that tribal people have their own distinct personal laws. They are not Hindus, they worship nature, not idols. They bury their dead instead of cremating. Their marriage and funeral customs are completely different. They are worried a UCC would erase all of that. The constitution already protects tribal customs, so legally you can't just force a uniform code on tribes without their agreement. That is why Uttarakhand exempted them. But here is the problem. If you keep exempting communities who object, you don't actually get a uniform code. You get a slightly less fragmented code, which raises the question, what is the point? Okay, so has anyone else pulled this off? Can we learn from other countries? Let's look at three examples. Turkey in the 1920s under Ataturk banned olive. They adopted Swiss law wholesale, shut down religious codes, banned polygamy, and gave women equal rights. It was forced modernization from the top. And yes, it created a progressive legal system, but it also caused massive cultural and political upheaval. Even today, Turkey is still fighting over religious role in public life. So that is one approach. Impose uniformity, deal with backlash. Indonesia took a different path. It is a Muslim majority country, but it balances Islamic law with civil law. Religious courts work alongside regular courts. Personal stuff like marriage and inheritance can go through religious courts, but things like child marriage and domestic violence are governed by uniform civil law. It is a hybrid, keeps pluralism alive, but sets a common floor for human rights. That might actually be closer to what India could realistically do. And Tunisia has the most progressive family law in the Arab Muslim world. They banned polygamy in 1956, made divorce equal, stopped child marriage, and they did it gradually with legal changes over decades. Building public support, it wasn't overnight revolution, it was step by step reform. That is probably the model that makes most sense for India. Not one dramatic UCC, but steady changes that bring personal laws in line with the constitution. So what do these examples tell us? Legal reform toward uniformity is possible. Other countries have done it, but it has to be gradual, democratic, and you can't just steamroll communities. You need discussion, consensus, compromise. The moment it looks like cultural domination dressed up as legal reform, you lose legitimacy. Which brings us back to India. Can this country, with all its diversity, actually pull off a uniform civil code? Maybe, but not the way Uttarakhand did it. Rushed, limited discussion, controversial things like live-in registration that feel more about control than rights. If India is going to do this, it needs to be done right. That means 1. Real public discussion, especially with women's group and minority communities. 2. Focus on actual gender justice, not just political symbolism. 3. Respect for tribal and cultural independence where it does not violate basic rights. 4. Gradual rollout state by state if needed with room to fix mistakes. 5. Constitutional safeguard to make sure this does not become a tool for one group to dominate others. Ambedkar put UCC in the constitution as something to aim for, not something to force. Maybe that is the key insight. It is a direction to move in, not a destination you rush to. And maybe the real question isn't should India have a uniform civil code, but can India create a legal system that is both equal and respects diversity, where women have the same rights regardless of religion, but communities don't feel their identity is being erased? That is the balance India has to find, and based on what we have seen so far, it is very much still a work in progress.